Hello, my name is Adrian Lifely. I'm a disputes and risk partner at the law firm Osborne Clarke. This video is the third video in the series looking at large business being used as HMRC's policemen, especially to catch tax evaders in the gig economy. In this video, we're going to be discussing what's called IR35, which affects personal service companies. You might have come across this tax issue in relation to the BBC newsreaders dispute. I'm with Ian Hyde, who's Osborne Clarke's head of tax disputes. Welcome again, Ian.
Thank you.
Can you tell us about this problem that the BBC had with IR35, please?
Yes, the BBC is perhaps the most well-known example of this, but there have been quite a few in recent years. If I can go back a few steps on this, there has always been a tax difference between self-employed and employed, and that creates a tension that's always been there, particularly around national insurance and other issues. There is a incentive for individuals, if they want to achieve tax advantages, to put themselves through a personal service company and be a consultant to a business rather than an employee. That is what happened in the BBC, and that's where we have these current issues around IR35. Obviously, with the gig economy and the increase in flexible workforces, the concerns have increased about this differential and the use of these personal service companies to try and reduce tax bills. IR35 has actually been around since 1999, and that's what the BBC case was about, where the test is, if you ignored the use of the personal service company, would the individual, the newsreader, be regarded as an employee for tax purposes of the BBC or whoever the large business is? And so if the revenue can establish that they would be employed, then you tax them effectively as if they're employed. So it's an anti-avoidance rule to stop use of these personal service companies.
Understood. And do the consultants in this situation, do they acquire employment rights? You say they're treated, you look at it as if they're an employee of the employer and ignore the PSC. Does that result in employment
No, they don't
rights?
actually. It's a fiction. It's a tax fiction, this test IR35. So it doesn't have any impact on employment rights. It just creates a tax test to look at avoidance, basically.
So what do you recommend that your clients should do about this? What are you saying to General Counsel, for example, about this new law that's coming in?
Well, the change is actually quite significant. This change is coming in April 2020, which is that the test itself of IR35 is not changing. So how you work out whether somebody is a deemed employee or not is not changing. What is changing is that the responsibility for paying the tax that follows is going to shift from the personal service company, from the individual, into the employer, into the large corporate. So suddenly large corporates are going to have to pay the tax for all their IT contractors or all their apparently self-employed off-payroll workers if they are found to fail IR35. Now, this has been brought into the public sector already. It was brought in 2017, but from April 2020, large corporates will be hit by this. And the reason for it is that the revenue have found it very difficult to chase individual contractors, because under the current rules, the revenue have to go after each contractor, which is proving very, very difficult. And the estimate from the revenue is some 1.2 billion of tax a year is going to be lost unless they do something about it. So again, as we were discussing in the other videos, this is about the revenue pushing the burden on large business because they're finding it difficult to find these contractors who are off radar effectively from the revenue. So the responsibility will be on the large business to make sure that they are determining the tax status of these individuals, their corporates, and if they get it wrong, they end up paying the tax. So it creates a real dilemma for large corporates, and they need to decide their strategy before April 2020. Are they going to take a cautious approach and assume that large numbers of these personal service companies are in IR35, and so they'll deduct tax at source effectively, like a PAYE, or are they going to be relaxed and just pay gross? In which case, if the revenue come after the corporate, then the corporate has a problem.
So I suppose for the corporate, on the one hand, the temptation is to play it safe and to not to pay gross. But on the other hand, they may end up paying more to contractors who want to pass on that cost of the extra tax back to the large corporate.
Yes, it'll be a the conversations I'm having with large corporates are around that combination of tax risk versus are you going to gross up the pay for these contractors who are going to effectively suffer a pay cut? Are these contractors going to go elsewhere to more relaxed corporate employers, so you'll lose talent? So there's a balance to be struck there, which I think for General Counsel and others, I think it's not just a tax issue this. I think that General Counsel and HR directors really need to get involved in this internal debate as to how they're going to set their strategy.
And do you have a sense of, you mentioned a global figure for the amount of tax that's being lost. Do you have a sense for how much this might mean for individual large corporates? How much money is at stake for some of our very large clients?
A lot. I mean, it's a very big tax risk. Large corporates are really concerned about this. It will have a big effect. If you've got 1,000 contractors, every year your tax cost could be in the millions from this. And indeed, a lot of the large banks are now making global decisions, effectively blanket decisions, that they will not engage anybody on IR35 terms. So they will require people to come on payroll or to be remunerated through alternative structures. So they're taking a very cautious approach, which has a knock-on effect, but they're clearly deciding tax risk in the way we talked about it in the first video, that inclination to be cooperative is really playing out as a cautious approach to this issue.
So there's a lot of work to be done now by large corporates in the private sector between now and April next year to get ready for this.
Yes, and there are a lot of internal discussions to be had. And the new rules in April will apply to payments made after April. So any contractor who is now being taken on the books 6 months ahead may well have payments that are in the new rules. So large corporates need to be thinking.
It's already an issue now.
It's already an issue.
Great. Exactly. Well, thank you very much, Ian. That's most interesting.
Thank you.